This shows, my lord, that they were trying to seek an appointment. They were trying to call Shiva. And my lord, Shiva first tells them to go to Delhi, etc. Now, one important thing here, my lord, that why this story of the prosecution seems to be cooked up. They feign ignorance in the story that they didn't know where I was. They tried to call. From the one other side, they said, no, it is trafficking. But if your lordship sees the cross-examination of the parents, they were very well aware of the fact that I was in Jodhpur from 11. And that is relevant, my lord.
Parents were aware.
Yes, my lord.
Where do you say that?
Yes, but I'll show that. Now kindly have, my lord, what I have done. If your lordships, use the 36A.
The parents were aware is your argument or
No, my lord, from the
it's the
material.
evidence?
From the evidence. I want to show that. So that's why, my lord, at every step, there are two versions possible. They knew, they did not know. So how is the conviction being made, my lord, by the trial court, my lord, is a question which I ask myself. Now kindly see the material, my lord, which I want to play straight away. Your lordships may mark this as 36A, my lord, in continuation of that page 36 which I had given. 36, my lord, is where the chart ends. If your lordship sees, my lord, what the mother says, this is in the cross-examination. यह सही है कि मेरे पति को बापू के सत्संग जहां होते थे मालूम होता था। यह कहना गलत है कि दिनांक 9 को मेरे पति को यह मालूम हो कि बापू कहाँ पे है। आज खुद कहा कि सत्संग से 4 दिन पहले ऋषि प्रसाद से, टीवी से और SMS से मालूम पड़ता था।
उसका नहीं पता।
This is an omnibus sort of.
Maybe, my lords, but I'm just wanting
Not
to
a specific knowledge of this time.
now kindly see further, my lord.
Then it is your argument.
Yes,
No
now kindly see, my lord. I have to place all this. I have to
All
place.
right.
I have to place all this, my lord, so that lordships may ultimately.
Point it out.
Yes, my lord. Now,
Generally, they had the knowledge. Whether specifically this
I agree,
time
my lord, I
they
agree. But ultimately, my lord, your lordships will have to see the overall holistic view. What is the position? यह सही है कि बापू के कार्यक्रम जहां होते थे तो अधिकांश साधकों को पता होता है क्योंकि उसका काफी प्रचार होता है। यह सही है कि प्रोग्राम के बारे में SMS और टीवी एक्सेट्रा से पर भी आता था, क्या वेबसाइट पर भी आता था एक्सेट्रा। Now IO also says the same thing. That's one thing, my lord. Then as far as, my lord, as far as, my lord, Jodhpur is concerned, my lord, one of the prosecution witness, I have quoted that is, my lord, the son of the farmhouse owner, also says 15 अगस्त तक जोधपुर में रुकने का हमारा यहाँ फार्म हाउस पर रुकने का बापूजी का कार्यक्रम पहले से निश्चित था। बापूजी यह कार्यक्रम 2 अगस्त को मैसेज के जरिए सभी को बताया दिया गया था। Now this has to be read, my lord, with the other things. So therefore, my lord, there is a possibility that they knew. Now why the story gets further falsified? Your lordships have seen, my lords, that they repeatedly called Shiva. That's the story, my lord. Right, my lord? Now I will show from the call details of Shiva on 12th, etc. No phone calls were made. Now that I want to show, my lord. Yes. Now kindly see, my lord. First.
no outgoing.
I'm sorry, my lord.
No outgoing.
Yes, my lord. I want to show that none, 0 calls, my lord. Then why are they simply taking Shiva's name is a question, my lord, which will, my lord, intrigue us. Now kindly turn to, my lord, paragraph 6. This is.
What does he say in his deposition?
Sorry, my lord.
What does he say in his deposition? Shiva.
शिवा मुल्की में से
Shiva acquitted, my lord. Acquitted. And that I will read, my lord, in a bit. Now kindly turn to, my lords, Sunita, who's the mother. जब हम शाहजहानपुर
उनकी केस डायरी में स्टेटमेंट्स रिकॉर्ड करते हैं, उनकी एविडेंशियल वैल्यू क्या हो सकती है?
इसमें मुलजिम की एविडेंस
बच्चे दाखिल के बयान लिखते हैं
कई बार मंजिल के भी वो पूछताछ नोट होती है, बयान नहीं होती। वो पूछताछ नोट होती है 161 में लिखते हैं।
जब 313 में सवाल जवाब नहीं कर सकते,
होती है, क्वेश्चन कर सकते हैं,
पर
वो क्वेश्चन वो थोड़ी पूछा करेंगे, इतना थोड़ी वो तो एविडेंस आती है उसको उतार देते हैं, जैसे पैसे भी क्लियर नहीं पूछते, वो तो कह देते हैं गलत है नहीं लिखाते सामान्य 90% सजेशन होती है, वो 90% केस में लिखते हैं ये बात गलत है। ज्यादातर चीफ जो होती है उसी को भी इंसल्ट करते हैं, जो क्रॉस होता है उसको कई बार पूछते नहीं 1313 में।
I was taking some tuition on the sessions trial because my brother judge has been sessions.
Yes, sir.
He was telling me how it is done.
Yes, sir. Lord, what I was to the specific question that whether they knew of this Jodhpur thing, because Lordships have seen that's all general earlier. Now kindly see this, my lord. जब हम शाहजहांपुर से रवाना हुए थे, this is the mother saying this. हमें पता था कि जोधपुर में सत्संग नहीं है, एकांतवास का बताया था. So they knew that he is in Jodhpur.
So when this person is acquitted,
Yes, my lord.
is this discussed?
Yes, my lord. The court said
in
there
his
is no
favor?
relation. There is no
In his favor,
in his favor.
Shiva.
Yes, my lord. But this is important because why are they coming to Delhi?
It was discussed in the manner as you are arguing what I meant.
No, my lord, not in the manner which I am arguing. They say, my lord, that there was no link as far as Shiva is concerned to the, my lord, act. That is what, my lord, the
There is
trial.
no finding that they were aware, so Shiva was not to be contacted, etc.
Nothing of that.
That's your argument here, based on
Yes, my lord. Now what I want
based
to
on
show,
what you're reading.
yes, my lord. Now what I want to show is, mother says they knew that they were in Jodhpur. And but he was in Ekantwas बताया था. आज खुद कहा शिवा ने बताया था. Now kindly note this, my lord. Around 10 or 11, before leaving for Delhi, mother was already aware that the appellant was in Jodhpur. The parents went to Delhi on their own accord, and to justify their stay in Delhi, they're introducing the name of Shiva. Now, my lords, why Delhi is very intriguing, because every time, my lord, this conspiracy to frame me happens, they are in Delhi. Whether this is the first time they come to Delhi, even after the incident happened, they first come to Delhi. And that assumes some significance when I'll come to why this is being done, my lord. Now, kindly turn to, my lord.
I think you're misreading her evidence. At
No,
least
my lord.
He doesn't state anywhere that she was aware that she.
That is clear, my lord.
How?
तब हम शाहजहांपुर
तो इसे हमें पता था कि जोधपुर में सत्संग नहीं है.
एकांतवास का बताया था.
हाँ.
एकांतवास of, my lords, of A1
एकांतवास कहाँ? That she
of
doesn't-
जोधपुर में. That
She
is what
said,
it says.
हमें पता था कि जोधपुर में सत्संग नहीं है.
एकांतवास का बताया
हाँ,
था. That's what it
एकांतवास.
says.
Where on earth एकांतवास can be Himalayas?
That is, no, according to us, it's
That's
clear.
you're reading into it.
Just one.
You're reading it. You're reading it. Then she says she volunteers. शिवा ने बताया.
शिवा ने बताया.
शिवा ने बताया था एकांतवास की जोधपुर नहीं है. We don't know.
We don't know, my lord. We don't know.
So
Now let us take it at face value.
So
Let's
there's no
take it at face value.
There's
Now
no
let us see, my lord. Let us say that Shiva had informed. They didn't know Shiva had informed. Let's take that case. Let's take that thread further. Now kindly turn to, my lords, this serial number 7. फिर हमारी शिवा से दिनांक 11 को कंफर्म करने के लिए फिर बात हुई थी, तो शिवा ने कहा वो दिल्ली को आ जाओ. Categorical, my lord. Shiva says that you come to Delhi. Now please have a look at, my lord, 139, exhibit 139, bar 6, which I have produced, my lord, at the fag end of this note. And what is the trial court number? This page number of in the trial court record, you will get, lordships will get it at, my lords, 2425. Just have a look at this chart, my lord, of the prosecution. This is on the 11th. Blank. This is, my lord, volume 6, page 2425. Lord, just have a look at this, my lord.
Yes. What do you want to say?
My lord, Shilpi between, sorry, my lord, between Pidita Parijan and, my lord's Shiva, there is no phone call on the 11th. No phone call. And I've shown that they say phone call. Why, my lord, they are saying involving this Shiva It's only to link me because the Shiva happens to be there. Why are they saying, my lord, all this? There's no explanation to this. Can't be any explanation. Now see further, my lord, back to my note. Then father says, my lord, paragraph 8 of my note, 36B. दिल्ली पहुंचकर हमने शिवा से बात की तो शिवा ने बताया कि बापू अभी जोधपुर में है और आप जोधपुर आ जाओ. So when they reach Delhi, they again call Shiva. And Shiva's, your lordships have seen the statement, Jaldi se aa jao. Now, if your lordship sees the call details on 12th, kindly have a look at that, my lord. That is 139/7 at page, trial court page 2426. No call. Kindly see this, my lord. No call made. So, my lord, at every stage, if the prosecution witnesses are lying, and I dare use the word lying, my lord, then your lordships will shift to the evidence of the prosecution with, my lord, circumspection and not take everything at face value. I've seen, my lord, lordships have seen improvements at every stage. On the May 2013 incident, 2nd, 3rd August 2013 incident, 7th, 8th, I have shown, my lord, Bhavya. Then, my lords, on the 9th, I have shown Sharad, that meeting of Sharad itself is doubtful. Now, between the 10th to 14th, my lord, all this happens. But what is the credibility, my lord, of these witnesses? Because ultimately, my lord, to frame me, sexual exploitation happens, my lord, in the darkness of the night, in the loneliness of a room. And the witness only says there's only one witness to that. Now, when they are saying all this, is it stellar evidence? Is it consistent evidence? Or is there a case of framing? Or is there two views possible why this could have been done? There was no need for them to lie. If it was a simple case that happened in a room, they could have simply said it. But all this baggage history is being created because that incident never happened. If that Bhutwali Ladki story had not been concocted, because this person never meets these girls in private, all the story would have collapsed. Because they started with May 2013 and to exorcise the ghost, the story is made that he made her come to the room. That is also demolished. I'll come when on the 15th. So if all the anterior goes, then your lordship will be very, very circum, because you are hanging a person on the basis of a testimony which, my lord, is ridden with improvements, major contradiction, and the witnesses are lying on the face. Now, my lords, kindly see, my lordships have seen on the 12th. On the 14th, my lord, there are calls. They reach there in Jodhpur. There are calls made at 10:30, 11:30. But the witness also says that a call was made. They reached Manai at 2:30. And then, my lords, they made a call. So they're very interesting. I can understand they made calls from the railway station. When they went to that ashram, which is 30, 40 kilometers from the station, doors were closed. So, my lord, they were asking permission to get in. How do they link me to this? They said, from the gate, I called Shiva, and Shiva, in pursuance of the conspiracy, let us in. That's very important. Just 1 second. Lordships have seen 15-20 people are waiting outside the gate. And, my lords, the case setup is, when they arrived outside, they made a call to Shiva, who was inside, and now, in concert, in conspiracy with A1, they opened the gates. And I'm going to show no call was made at 2:30. How they managed to get in, we don't know. They must have contacted a few other people. So again, here the conspiracy breaks down. 376 D breaks down, 370 breaks down. And to a great extent, my lord, the story of 375, my lord, starts getting doubtful. That's all I say, 375, my lord, I have not gone into, but it starts getting doubtful for sure. Now kindly see, my lord, PW5 about the call of 2:30. हम लोग 13 अगस्त की रात्रि को दिल्ली से रवाना हुए। 14 अगस्त की सुबह जोधपुर पहुंचे थे। मम्मी पापा और मैं तीनों साथ में थे। 14 अगस्त को सुबह 10:30-11 बजे के करीब जोधपुर पहुंचे थे। फिर पापा ने शिवा से फोन पर बात की थी कि बापू कहाँ पर है। तो शिवा ने बापू को पूरा पता पापा को समझाया था। फिर हम लोग ऑटो से मणि आश्रम पहुंचे थे। जो शिवा ने बताया, मणि आश्रम हम दोपहर करीब, दिस इंपॉर्टेंट, मतलब काइंडली मेक अ नोट, 2-2:30 बजे पहुंचे थे। मणि आश्रम का बाहर का गेट बंद था तथा गेट पर करीब 10-15 लोग इंतजार कर रहे थे। फिर शिवा को पापा ने फोन करके बोला कि हम लोग यहाँ पर क्या आ गए हैं, परंतु गेट बंद है। तो शिवा ने कहा अभी गेट खुलवा देते हैं। फिर थोड़ी देर में गेट खुल गया। नाउ काइंडली सी माय लॉर्ड्स व्हाट द फादर सेज। यह कहना गलत है कि हम 8 बजे जोधपुर पहुंचे हो। आज खुद कहा कि मेरे अंदाज से 10 बजे पहुंचे थे। हम रेलवे स्टेशन पर नहाए धोए थे। नियम किया था। स्टेशन पर कितनी देर रुके थे पूरा समय ध्यान नहीं। आज अंदाजन 2-2.5 घंटे लगे होंगे। जोधपुर रेलवे स्टेशन पर पहले 9:15 10:30 बजे लगभग पहले शिवा का फोन आया था। आज खुद कहा कि उसने पूछा था कि कहाँ तक पहुंचे हो। उसके बाद हमने फोन किया था। यह कहना गलत है कि उस दिन 10:17 या 51 सेकेंड पर पहले फोन शिवा को हमने किया हो। यह कहना गलत है कि उसके बाद हमने जब शिवा को रास्ता पूछने के लिए फोन किया था तो उसके 3-4 मिनट बाद में शिवा को फोन आया और टेम्पो वाले को रास्ता बताया। आज खुद कहा कि टेम्पो वाले से बात 11:45 के लगभग करवाई थी। शिवा के टेम्पो वाले से एक बारी बात हुई थी। उस दिन एक आध बार शिवा का फोन आया था और 3-4 बार हमने उसने बात करी थी। पूरा ध्यान नहीं। स्टेशन से 11:45-12 बजे टेम्पो से रवाना हुए थे। रास्ते में खाने के लिए रुके थे। टेम्पो वाले ने तेल भरवाया था। मणि पहुंचते पहुंचते लगभग 2-2:30 बज गए थे। टेम्पो वाला रास्ता में लोगों से रास्ता पूछते पूछते गया था। और दिस वेरी इंपॉर्टेंट, पूछते पूछते गया था। एज लॉर्डशिप से वी आर ट्राइंग टू सीक एन अपॉइंटमेंट। हाउ इज ट्रैफिकिंग मेड अप। मणि गांव में टेम्पो वाले ने ही रास्ता पूछकर फार्म हाउस तक पहुंचाया गया था। मणि फार्म हाउस पहुंचकर जब गेट बंद था, 15-20 आदमी, तब मेरी फोन पर शिवा से बात हुई। नाउ काइंडली टर्न माय लॉर्ड्स टू द लास्ट एग्जिबिट, 139/9. There's no phone call. Morning, my lords, 10:17, 10:51, 10:42, 10:44, 10:20. This is all the phone call. Why are they saying at 2 p.m.? That is only to show that they spoke to Shiva and then the gate opened. Why are they saying all this? Is there a story to be made? If it was an, my lord, real case, there was no need to make up all these stories. You could have simply said, I went there. When we are going to the core allegation, all this, my lord, history will be a relevant factor which will be in the back of your lordship's mind in coming to a conclusion whether the evidence of the prosecutrix of what happened on that day is at all credible, can be believed in toto, or is there, my lord, some improvement which runs through this and which creates a doubt on the happening of the incident. Because according to us, my lord, no incident happened. My lords, now they have reached on the 14th. Now, my lords, on the 14th, before I go to the 14th, my lord, I want to finish this 370, my lord, little bit of law, if your lordship permit me. Because really, the 370 story ends here, my lord, 14th onwards, little bit of 120B, and 15th, my lord, 375. Your lordships have very The lordships have seen my lords 370 with me on the last occasion. As your lordships rightly put to me, my lord. First part of 370 is or, the 5 ingredients. And, my lords, firstly, or secondly, or thirdly, or fifthly.
Is
fourthly,
13 your lucky number or what?
Sorry, my lord.
Is 13 your lucky number?
13, my lord.
Your note starts at 13.
13?
Page 13.
My lords, we'll give, the first few pages, my lord, was introductory submission. Just give the first few pages.
No, it's all right.
No, my lord.
I was just wondering that the count for you
Actually, it's
starts
my
at
lucky
13.
number because my house number is F13, my lord. Well, anyway, my lord.
That's why we thought there must be something to do with it.
No, my lord, but I'm just saying.
Because your counting begins at 13.
First 12
Your notes
pages.
start at
Yes,
page
yes, the first 12 pages, my lord, are who are the witnesses. Who, my lord.
My court number was throughout 13 in Punjab, Haryana. Before that, it was 12A.
Right.
Because the predecessor judge thought 13 is unlucky number. So he had numbered it 12A.
Just give the first 12 pages.
When I was allotted that, I found it into 30.
Just give things. Let's finish up.
Anyway, I'm not that you don't want to cite, it's fine. Because it starts at,
No, but first 12 pages are only introduction. Because
That's all.
started with my submission. I just,
don't burden us with it.
no, it was only the chart of what.
All right. We just said.
Yes, no, I was at
We
375.
just wanted to tell you that we got it from 30.
Yes, yes.
We don't have one.
I just complete that out. Just not 375 your lordships have. ये 12 तक है. 370 if your lordships have. Your lordships have seen, my lord, whoever for the purpose of exploitation recruits or transports or harbors or transfers or receives by firstly or secondly or thirdly or fourthly or fifthly. So, my lords, first half, any of the 5 and any of firstly, secondly, thirdly, fourthly. The trial court in this case, which I'll come to in a minute, says forget about the first part, A or B or C or D or E or E. What is proved against you is fourthly and fifthly. Fourthly and sixthly. And therefore, 370 is made out. Now, my lords, lordships have seen, I'll go one by one. Recruitment, my lord, will not apply. Transportation, in my respectful submission, will not apply at all. I have not transported them. Harbor. Now, my lords, what is the meaning of harbor? In the general explanation, your lordships will see the, I don't know if it has been shown to your lordships, section 52 in the general explanation. What is the meaning of harbor? Yes. And this has been explained by the Supreme Court also. 52A, can I put? Except in section 157 and in section 130, in the case in which harbor is given by the wife or husband, etc. The word harbor includes supplying a person with shelter, food, drink, money, clothes, arms, ammunition, or means, or conveyance, or the assisting of a person by any means, whether of the same kind or not. Now, the last part is important, my lord, to evade apprehension. But that is the crucial part of harboring. That you do all these things, you help that person to, my lords, to give them money, clothes, arms, ammunition in the secrecy, to avoid apprehension that you're doing an illegal act. The very act of harboring, my lord, involves a certain degree of secrecy. That is what the Supreme Court says, my lord. And that judgment is just give that. That's on the harboring part. So there is no harboring by me. Even if they have stayed on the 14th, it's all open. They have come to me. Anybody who comes to the ashram, my lord, welcome to stay. Your lordships have that judgment. the last judgment in this, my lord, the first judgment, Kalpanath Rai. My lord, this is a Tada case. And lordships are aware, my lord. The Tada also uses the term harbor. Now, my lords, I must clarify here that, my lords, as far as what is disruptive activity, my lord, under the Tada, my lord, that to that extent, my lord, this judgment, my lord, has been subsequently clarified. But as far as this judgment is concerned on the definition of harbor, my lord, this stands as a good law. I must clarify that. If your lordships have page 18 of this compilation, first, my lord, on the top of the page, 2.1i of Tada, words and expression used but not defined in the act and defined in the code shall have the meaning respectively assigned to them. So, my lord, the court, the Tada relies on the CRPC. Then, my lords, what is the definition of CRPC? That is noted in paragraph 51, which I just read. Paragraph 51, section 52A, which I just read, my lord. That I will not read. Now, what the Supreme Court says about harboring. The word harbors, paragraph 53, used in Tada must be understood in its ordinary meaning as for penal provisions. In Black's Law Dictionary, its meaning is as shown as to afford lodging to shelter or give a refuge to. Quoting from so-and-so American court, the celebrated lexicographer has given the meaning of the word harbor as receiving, kindly note this, my lord, for your lordship's consideration, clandestinely, and without lawful authority, a person for the purposes of so concealing him that another having a right to the lawful custody of such person shall be deprived of the same. The harboring means, my lord, that I take the girl, the parents have the custody, I take her in a manner.
In the context of Tada, when you're hiding from law, let's do it.
Correct. Even otherwise for trafficking
hiding
also.
From law, you apprehend that in case you don't observe this discreetness of shelter,
It'll be exposed.
you'll be exposed to law.
Correct. That same thing also applies.
Either apprehended or what.
Yes, the same thing applies to trafficking. Because the court is borrowing.
This 370 reads it differently.
Sorry, my lord. No, 370
reads.
No, my lord.
Reads harbor.
The word
370 reads harbor differently.
My lord,
it reads it as it is yet to happen.
Correct, my lord. But
exploitation.
My lord,
for the purpose of exploitation. Exploitation is yet to happen.
Correct, my lord. For the purpose of sexual exploitation, if I am harboring, the meaning of harbor is settled. That is under 52A. And 52A.
As they would argue,
yes,
that the sheltered did not know that the shelter is being provided with the ill motive of exploitation.
There is no, who is providing the shelter? There's no allegation that I provided shelter. There's no allegation. They come on their own, your lordships have shelter. If I am providing shelter, it means that I'm doing an overt act. So anyway,
shelter, as they would argue, perhaps shelter in this case does not mean shelter in physical form, but shelter in spiritual form. That they were providing you, go to Baba, he'll accept.
But all that is demolished, right from 10th onwards. I've shown that there is no phone calls made by us. There's no phone calls made by us. And my lords, I am not doing any activity to avoid apprehension. But ultimately, harbor has to be fitted in 52A. And 52A is very clear what has been defined by the Supreme Court. The prosecution cannot get out of this. I'll read this, complete this, my lord. In other dictionaries, the meaning of the aforesaid word is delineated almost in the same manner. It is therefore reasonable to attribute a mental element as indispensable to make it a penal act. But so therefore, harboring is not made out. Then my lords, transfer.
No, see this whole whatever web of so-called deceit which the prosecution is alleging qua you is not in the physical form. It's the concept of this taking the evil spirit out of the victim, the whole process of exorcising That is being turned as she was being sent to Baba's shelter. In that,
My lords, so, my lord,
that is the shelter they're seeking from you,
my lords, may I just
so that while providing that shelter, you use your spiritual powers to exorcise the evil spirits.
yes, ma'am. May I respond to that, ma'am? That may not be the correct, my lord, reading of
We must
370.
go into the context
My lord, just
of,
I'll explain why, my lord. I'll just
context of how the trial
yes,
court would have
Correct,
possibly
correct.
used
We
this
have to understand
to
that.
fit you
Absolutely.
into her.
Correct, my lord. I'll
Right
answer
or
that.
wrong, we yet to
Correct,
decide.
my lord. Correct. Now, what your lordships are
Because
putting,
if you'll keep laboring on the physical part of it, you're leading nowhere.
no, my lords, I respectfully submit. A, B, C, D, E is physical. There are no two ways about it. Kindly make my submission, my lord, that I am making it. I am making no two qualms about it. A, B, C, D, E has to be physical. Whereas firstly, secondly, thirdly, fourthly, fifthly, sixthly is
को
mental.
दे दिया था तो उन्होंने लिखा कि 370 के लिए कस्टडी प्राप्त करना आवश्यक नहीं है 371 सीएम के 4-6 तरीके के अनुसार कपट
But the trial judge has said it.
Yes, but I'll just
Find
explain.
it-
I'll come to the trial court straight away, my lord.
1C and
My brother, that is
1C and 1D in
Trial
Yes,
judge
sir,
says,
See only
trial
one
judge has
C,
also
1D.
said it doesn't have to be physical.
That's wrong, my lord. That's wrong. So I'll just explain why.
कस्टडी आवश्यक नहीं है 1 सीएम के लिए 4th and 6th fraud and
My lords, kindly see the section again with me if your lordships have the section, my lord.
fraud and deception और
Yes, sir.
ट्रांसफर के लिए कंसेंट इनकी लेकर उनके थ्रू ट्रांसफर करें
My lord, I'll make it, my lord, very, for my submission, my lord, I'll explain how, whatever best I can, my lord. A, B, C, D, E are all physical acts. There cannot be a mental element to it. But firstly, secondly, thirdly, fourthly, fifthly does have a mental element. Please have a look at the section very carefully. There cannot be, in my respectful submission, two views on this. Kindly have a look at this, my lord. Recruitment. Recruitment is a physical act. I can be roped in with 120B in somebody doing the recruitment, but recruitment can't be a mental act. Then, my lords, transportation. Transportation is a physical act. Somebody is
Extend
transporting.
your
I am
argument
assisting. I'm sorry.
extend your argument further.
Yes, ma'am.
You say since A to E
Yes.
has to be along
Physical.
with first to six.
Huh.
If A to E does
Not
not
made up.
exist, then first to six.
No,
is
doesn't
correct.
that? That's my first point, madam. That's the first point.
वो C और D में ले रही है
Because it is not either or.
It's not
I'm
either.
saying it has to be either A to E and
Yes, my lord.
any of the six.
Yeah, go down. Go down.
You're reading it as and.
Correct. It has to be and, my lord.
and
my lords-
एंड मान रहा बट ट्रायल कोर्ट ने C and D
I
ने
was
लिया
framing his argument.
ये
Now, my lord, C. Let's see, my lord, C. Whether C harbors. What is the allegation that I have harbored? Harbored is a physical act. Not harboring, giving food, giving shelter, my lords, giving drink. That's what 52A says. It is a physical, there is nothing mental about it. Trial court is completely wrong. If you see 52A, acts are all physical. And, my lords, then the transfer. Transfer is a physical, I get that person, then I transfer that person from one place to the other place, from one house to the other house. It is not transportation. There's a difference between transportation and transfer. Transportation necessarily means that I use a means of transportation to get that person by bus, car, railway, plane, etc. Transfer means from one house to the other house, or, my lords, on foot, I take them. There's not transportation. So it's a physical act. There can't be a mental, my lord, element कि अपने mentally उसको, I am not that strong, my lord, to mentally transport. My lord, in Vedic, this thing they used to mentally transport, my lord, people from one place to the other. That is not the case in Kali Yuga. You have to be physical. There, A to E have to be physical. Now, my lords, will come to firstly, secondly, thirdly, fourthly.
Hypnotism.
Hypnotism, my lord, you can't, my lord, take a person.
Mentally transfer. You physically
But I can in my mind go to some other country, some other place, my lord, but I don't know if that any person has the power in this world to transport him from Jodhpur to Delhi mentally. But anyway, my lord, let's leave that. Now let's see, my lords, firstly, secondly, thirdly. High Court, the trial court, my lord, says by practicing fraud or deception. let's assume, my lords, that A to E, which are not fulfilled, are fulfilled. Figment of imagination, my lord, let's stop that, my lord, prosecution. But now see, fourthly, by practicing fraud.
So, arguendo, if we were to believe in A to E,
Yes,
which
no.
part of A to E?
Yes, which part? I'm saying nothing, my lord.
That is your argument.
I don't know, my lords.
So what has the trial court?
Trial court
C
says,
and
my lord,
D.
C, harboring. Wow, how harboring?
He
my lord?
also transfer.
E,
C and D.
C and D. How?
C and D.
Yes, correct, my lord. That's what I want to. How?
E.
No,
D transfer how?
ट्रांसफर स्थानांतरित
Transfer how?
स्थानांतरित में ट्रांसफर रिसीव है ये तो रिसीव रिसीव तो लड़की को माँ बाप को दिया सर वो नहीं मदर ये कह रहे हैं कि मदर फादर को दिया हैंड ओवर किया उसके ट्रांसफर के लिए उसको कंसेंट लेके उसको साथ में लेके जाए ट्रांसफर में सहयोग किया मदर फादर ने बाबे से मतलब नहीं वो तो उनके थ्रू है ट्रांसफर कैसे आ रही है स्टार्ट ये सब की स्टार्ट वहाँ वो इनका भी है कि यहाँ से स्टार्ट हुए 4-5 दोनों मिलकर ट्रांसफर किया इसके पास उसने तो रिसीव किया बट ट्रांसफर
But in fact, just to, my lord, assist your lordships, the trial court has, in my, whatever we have read, my lord, it has not said D. Only C, my lord.
नेक्स्ट स्थानांतरित व्यक्ति या और
But the conclusion is, if your lordship sees, my lord,
पेज 429 जजमेंट
yes, my lord. If your lordship sees the conclusion,
यस
in Hindi, it says Matra Dhara 370
1C के हाँ
हाँ,
आगे पढ़ो
के 4 व 6 तरीके के अनुसार कपट व प्रवंचना करके
या स्थानांतरित हाँ,
व्यक्तिपद पर नियंत्रण रखने वाले व्यक्ति
हाँ, स्थानांतरित किए करे
But-
स्थानांतरित ट्रांसफर वर्ड मीन्स स्थानांतरण
yes, my lord, but I don't understand. My lord. First he says C,
सी एंड डी
D. Anyway, my lord, let's assume it is D. No, I don't want to get.
C precedes D.
C precedes
First
D,
you give
but
shelter,
correct.
and then you
then D
But my lord, C, your lordships have seen harboring is a physical act.
और
E transfer is a physical act, not a mental act.
नोट कर ले आगे
Yes,
नोट कर ले
Yes, ma'am. Now, my lords, kindly see, fourthly, by practicing fraud or deception. This theory of fraud or deception, my lord, I have brought in great detail. This entire thing that she was told that she is possessed by bhoot is, according to us, my lord, completely concocted because neither Shilpi said it nor Sharad said it. It was said for the first time by Bhavya. If it was said for the first time from Bhavya, who's practicing fraud? On her, on the prosecutor, Bhavya is practicing fraud. Is there any material that after Bhavya said that you are possessed of ghosts, they all contacted A1 and then they said, oh, we have to now indoctrinate her into believing that she is possessed of ghosts, and then, my lords, let us make her transport to A1. There's no such case being set up by the prosecution. So, fourthly, in my respectful submission, similarly, my lords, sixthly or fifthly, whatever it is taken, my lord, doesn't, by inducement, including giving or receiving of payment, benefit that not in order to achieve the consent of person. No, sixthly will apply where, my lord, I am undertaking, my lord, the person, taking the person for the purpose of recruitment, transportation, harboring, transferring or receive. Sixthly will apply only, my lords, in the context of the A to E. But anyway, my lord, this, according to me, it's clear. It is not made out as far as 370 is concerned. Now I straight away come to, my lord, my submissions on 370. If your lord, Lord, there is one other judgment on, my lord's recent judgment of Honorable Justice Suryakant on this harboring, on this 370. It was a very interesting case. Kidnapping. One of the ingredients was kidnapping, and allegation was, my lord, there was a maid. She was, my lord, she made a complaint that certain persons trafficked her, got her to her employer, and the employer, she was with the employer. Then she says to the employer that I am not willing to work. I need to go back. Employer, my lords, kindly note this. He locks her inside the room, but gives her a mobile. You can contact. And you can go when I find a suitable alternative. He was roped in for trafficking. Although one of the facts was that the girl did say that I have nothing in particular against my employer, but 370 just can't go by consent or a compounding. So, my lord, the court went into the question as to whether 370 is made out. And then, my lords, in that context, please have a look at which Ajay Malik, that's in the compilation 2025, SCC Online, SC 185. The facts, my lord. The judgment starts at page 29. Yeah, my lords, this person Ajay Malik is the accused. At page 36, P 1.1 offenses alleged against Ajay Malik. Analysis in this regard will address each of the offenses enumerated against Ajay Malik, namely wrongful confinement 343, human trafficking under 370, and my lords, criminal conspiracy. Now, my lords, on this trafficking business, if your lordships have paragraph 18 at page, my lord, 38.
30.
We now turn to the allegations against Ajay Malik under section 370 of the Act. I'm sorry, my lord.
Yes.
And other co-accused. However, closer examination revealed that the bulk of the FIR primarily on two neighbors, etc. Not. In the complainant statement against 164 CRPC, allegation against seemingly diminished. She provides a detail of her neighbors, etc. Then we'll leave that. Then there is a no objection which she gives. And then, my lords, if your lordship sees, my lord, that second paragraph. In contrast, the second paragraph of 18, the only mention of Ajay Malik in her statement pertains to his alleged refusal to send her home until alternate arrangements were made and his having allegedly locked her in a room. The complaint also notes that Ajay Malik had left a mobile phone with her before leaving for Delhi and maintained regular contact with her during that time. So please note this, Miller. Employer puts the employee in a place, gives her a mobile phone, locks her from the outside. Question is, was it trafficking? Court says no. That your lordship will find. Para 20. In this vein, having duly considered all these aspects in total, we are of the opinion that no prima facie offense 370 has been made out. Not only there is no evidence of neglect or exploitation by Ajay Malik, but our own so-and-so abuse also may be given. We deem it important to note that there may have been instances suggesting some degree of labor-based exploitation of the complainant. This is not evident from the face of the record, and we are not inclined to initiate an inquiry into this. In any event, such allegations do not constitute offense of 370, and we cannot conclusively find Ajay Malik guilty of trafficking and exploits. Lord, this is a worst case where that person locked her in a room. There is no mental element, my lord, in this. And here, my lord, there was a clear, either it is harboring or, my lords, it was a clear case of harboring because he put her, but the court said, no, this is not even harboring because you gave her access and it's not done clandestinely. If it's done clandestinely, the mobile would have been taken away. Now, my lords, my submissions on this, if your lordships have. Lords, that lords, what page is it? No? Okay. Anyway, just show it from your lordships have, my lord, page Your lordships have page 37
notes.
of my note, my lord.
Yes.
Lords, I have extracted, my lord, what the section is. And then, my lords, I have explained what the, my lord, according to us, where our submission, where our, my lord,
This you
submission.
already argued.
Yes, I have already argued. I just want to point out, I have put it down in writing, my lord. Then, my lords, I straight away turn to how the trial court has dealt with this in paragraph 53. I'll just read this and then I'll come to the trial court. The learned trial court in para 450 commits a grave error by holding that receiving custody or making out the offense is not necessary and the offense is complete through ingredients of fourthly or fifthly by practicing fraud or deception or abuse of power or by inducement. Observation is completely misplaced, no evidence. Then, my lords, kindly turn to 55. Evidence on record also shows that there was no attempt made by either of the accused person to follow up or put any further pressure or mind in the mind of the prosecutrix or a family to ensure that they don't go anywhere else after the 10th or after the 9th when they left or immediately reach the place where the accused asharam was. Once the prosecutrix was taken home on the 9th, the control and the custody of her was with her parents and the element of fear or inducement was broken. Hence, there was no continuous or constant fear or pressure by the accused person which could infer the control of the prosecutrix. That is for fifthly and sixthly. They still have to satisfy my lord A, B, C, D, E. It is also relevant to point out that.
You got the drift of your argument.
Yes, my lord. I'll just finish this quickly.
As far as 370 is concerned, you say that they were set free from the Guru.
Yes, yes, no. Yes, that's the.
They were on their own throughout.
That's right. That's right.
It was only one-way traffic. They were trying to reach out,
That's
taking
right.
time. Whether
But just how the
whether
trial court.
Jodhpur, whether Delhi,
Correct,
this,
correct,
that,
whatever
this,
it is.
that. So 370
Correct.
not made out
Yes.
at all
That's right.
on all squares, whether it's A to E or
Yes, my lord.
firstly to sixth.
But just to buttress that, if your lordship sees
You
56
can move
also.
on from there now.
Yeah, I'll just move on my lord, quickly.
And of course, you would argue that if 370 principal offense is not there, where's the question of 120B?
120. But 120B, my lord, also has some bearing on 376D
You
also.
would of course argue that
Yes.
even if the trial judge were to say firstly or sixthly, whatever,
Yes,
in the
correct.
absence of A and
A
B,
and B,
you can't
correct,
have
correct.
bits and pieces.
No,
You
just
can't have bits and pieces of 370
That's right.
and then invoke 120.
correct, correct. Just have also 56, but I want to read the evidence. It is also relevant to point out. I have tested your lordship's patience enough. I want to hurry this up. It is also relevant to
Yes,
point
we are
out.
saying come to the principal.
Yes, but I just come. Kindly see this because I just want to complete.
We must honestly tell you were not in. Mr. Jain is also argued. Mr. Vineet Jain
Yes,
has
my lord.
argued.
But I am also saying, my lord, that all this is relevant.
Because in that case, the principal offense is 370 in his case.
Correct, my lord. But what I'm saying is, for me, everything is a principal offense. Everything is bogus. Everything is principal for me. I want to clear my name, my lord. Because trafficking is something for a spiritual. It's really bad, my lord. 375 is worse. But I want to get rid of it. But just that's why, my lord, I'm laboring on this. 56.
Sir, you don't have to.
Yes, my lord.
What we're saying is you made your point.
Yes, I bow down, my lord. But just 2-3 things, my lord. Not sometimes, my lord, we are a little anxious that all the points should be there before the court, my lord, that we should not, as lawyers, not miss out on any point. That's
But
why.
that is why this labor you've done.
Yes, ma'am. Now, para
If you miss
56.
out, then there's a problem.
Yes, ma'am. I just want to just point that out and leave and not argue more than 10 seconds. Not IO 40, who's PW 43, in her cross-examination, has admitted between 9th and 16th, there is no evidence of any telephonic conversation or follow-up by Shilpi with the prosecutrix. Now, my lords, paragraph 458 of the trial court is also important. Lordships may note, I will not read the trial court. The trial court categorically observes that in the case in hand, there is no direct evidence available against accused Sharad and Shilpi that sent the victim to accuse after that he might sexually exploit. However, oral and circle present on the file covers clearly that physically was frightened by evil spirit. That thing has been broken, my lords, from the, if at all there is on the 9th. Then, my lords, kindly turn to 467 yeah, that's what has seen. Then, my lords, then I want to show, my lord, the Prakash. I have shown, my lord.
ये फाइनल स्कोर 50 है। मुख्य परिचित के साथ सिद्ध है कि पूर्ण रूप से स्वस्थ पीड़िता को दोनों अद्भुत गण ने भूत प्रेत का डर दिखाया, परिवार को प्रवंचित कर उत्प्रेरित किया कि भूत के इलाज के लिए अद्भुत आसाराम से बात हो गई है, कहीं नहीं और कहीं नहीं ले जाओ, सीधे उनके पास आए। इस तथ्य से आसाराम के साथ इस षड्यंत्र में शामिल थे, इसलिए वहां भेजा।
Now, my lords, 370, one other aspect, my lord, is regarding this person Shiva. I have read, my lord, Prakash, that Prakash, my lord, 400, they tried to call. There's no phone call, not a 400, my lord, doesn't belong to Prakash, it belongs to some Bhadoria, right, my lord? And that trial court has categorically said that that number was not with Asaram. And your lordship asked me a question which I faltered, my lord, in my, because the evidence was too much. Lordships asked me, are the call locations of 400 available? Now, my lord, there is a little bit of story to that. According to us, my lord, it has not been proved because the nodal officer, my lord, who was brought in as PW44, he was not the nodal officer. There's no gazette. They got somebody to prove this call locations. Now, the call locations that is discussed by the trial court while exonerating, my lords, this phone number for association to me, and says that this number, my lord, used to travel with this Bhadoria. He was in Bamer, he was in Siroi, etc. But there is no evidence to link it to me that I was using this. And court says, my lord, using the basics of criminal, that suspicion, however strong, my lord, will not replace proof. So that's why, my lord, on that 400, my lord, Prakash is out. Now, as far as Shiva is concerned, if your lordships have the trial court judgment, which paragraph? 419. It is, my lord, in the judgment compilation, it starts at
Para
419, page 530, my lord.
para 41.
Yes, my lord, para 419. Lord, at page 531. Lord, sir, lordship are reading the Hindi version. Yes, Hindi version is page para
453.
Yes, 419. The next paragraph, page 531. Thus, in whole, the middle of that paragraph, your lordship got it.
Para
Lord's page 419. Lord, yesterday I think we had given that English another copy, I think.
English translation.
I think that is the one.
English
Translation. That's the one.
Yes, sir.
Yeah, just in the page 531.
Yes. 531.
Yes, sir.
This one.
Yes, sir. In the middle of the 10 lines from the bottom. Thus, in this whole event, the role of Shiva has been telling the address of accused Asaram upon asking by Karamveer Singh. It is notable that the call detail of record of Shiva is not proved. Therefore, this is important for 370. And also, my lord's common intention, my lord, for the purpose of 376, the call details are not proved. This is not the prosecution version of Shiva himself would have phoned PW21 and explained the address which has been prepared by the IO about the calls side in conversation has not been shown. Conversation of Shiva with the accused Asaram has been shown through Prakash, but as per the previous deliberation, it has not been proved that 400 remains with Prakash, which accused Asaram used to use. In such a situation, in my humble opinion, there is not even a little evidence on the case file to connect Shiva with the alleged crime. Then, my lords, ultimately, paragraph 427 is the not clean chit. Therefore, it is clear from the above deliberations, prosecution has completely failed to prove this case against accused Shiva, as the accused Shiva at some time prior to 15, together with Asaram, constituted a criminal conspiracy and gang with purposes of to do exploitation of a prosecutor and provide any support in furtherance of the criminal conspiracy and common intention with the purpose of sexual assault of the prosecutor. Now, my lord, conspiracy with Shiva, not there. Conspiracy with Prakash, not there. Only 2 person else who I can conspire with is Shilpi and Sharat. No link to me except through these 2 persons. And Justice Gawai's latest judgment, that judgment is there, my lord, that if the allegation is conspiracy and the link in the conspiracy is broken, or the other co-conspirators have been acquitted, there's no question of sentencing these people for conspiracy. I'll straight away come to the conspiracy angle, my lord, now on the law, and then I'll come to 14th, my lord, on this Bhutwali Ladki. If your lordships have, since I'm doing this conspiracy, the earlier judgment. 120B also, my lord, on 370 has been roped in. Both for, that's why I just want to satisfy your lordships on that. Just 1 or 2 judgments, my lord, on this, I guess not. But it's law well settled, but my lord, straight away, if your lordships turn to, my lords, Lords, first, serial number 28, 2012, 9 SEC, page 670, the 696 at page 272 of the compilation. At page 278.
Sorry, I missed it there.
That's one is the compilation.
New judgment.
Same.
No, my lord, that's another compilation.
Another compilation.
That is compilation 2, my lord. This is compilation 1.
Is that scanned?
No, my
Not
lord,
scanned.
my lord, we'll just
Not
scan it during.
scanning
Yes,
now.
so we'll 270. Yeah, it starts from page 272 at page 278.
Start reading in the meeting.
I'll read it, my lord. Lord, this is bringing a cold to Newcastle, my lord, but I'll just do my duty now. The offense of criminal conspiracy has its foundation, where an agreement to commit an offense or to achieve a lawful object through unlawful means.
278 page.
Page 278,
Para 15.
para 17.
15. The offense of criminal conspiracy.
The last, I don't want to read the.
Same as the offense of criminal
Yes, yes. Such a conspiracy would rarely be hatched in the open, if therefore direct evidence is not available. Proof or otherwise is a matter of inference. In drawing such an inference, the court must consider that the basic fact and circumstance which an inference is to be drawn have been proved beyond all reasonable doubt, and thereafter from such proved and established circumstances, no other conclusion except that the accused had agreed to commit the offense can be drawn. May 2013 happened, not happened. What happened? Did that touching happen? Not happened. 2 views. 2nd, 3rd August, my lord. Bhutwali, that Bhavya happened, not happened. 2 versions, 2 inferences can be drawn. 7th, 8th, calls were made. Your lordships have seen. Calls were made. Whether calls were made, not made. 2 inferences. STD, the STD booth numbers, my lord. 535062, not belonging to Shilpi, not in the possession of Shilpi. Only 62. IO says, bring the 62. It is confiscated. And then the trial court links that 62 to me. No evidence otherwise. And that she was asked to bring. So 2 inferences possible. Going further, my lords, whether, my lord, when they met, allegedly, my lords, in Sharat's room, Sharat told her, you are possessed. Don't go here and there. Unhi ke paas leke jao. 2 inferences possible. This happened. This did not happen because the entry in the register with the prosecution itself says every time you enter the school, you have to enter and you record your name. Your name is not there. Then, my lords, we go further, 10th to 14th. I have shown, my lords, they again and again say, we called Shiva. There are no calls on 11th, 12th, and even on the 14th at 2:30. Why are they doing all this? Are 2 inferences possible? I respectfully submit yes. Now, that is, my lord, as far as this judgment is concerned. Yeah, okay. Naturally, in evaluating the proved circumstances, for the purpose of drawing any
Benefit
inference.
of doubt.
Adverse to the
Benefit of doubt must go to.
That's
That's the last.
Yes, yes, sir. Then, my lords, the next judgment is the Parliament attack case. That's the lords main judgment. We all rely on criminal conspiracy, my lord. The law from England, etc. Everywhere has been discussed. I'll just point out the paragraph. Lords may, my lord, consider it. But the judgment starts at page 281, and the relevant judgment, relevant portion, my lord, at page. Just one second. 369 onwards, my lord. Lord, what is conspiracy, my lord, is 92, Hari Singh Gaur, 94, I want to read it, my lord. Now, but 96, I just want to place it, my lord. That is Kehar Singh. It is, however, this is important, my lord. It is, however, essential that the offense of conspiracy requires some kind of a physical manifestation of agreement. This is important, my lord. When we were talking of 370 or 376D, trial court says no, mental element is enough. Fraud and deception. But where is the physical element? The physical element is A, B, C, D, E. There's no physical element here. The express agreement, however, need not be proved, nor it is necessary to prove the actual word of communication. The evidence as to transmission of thoughts, sharing the unlawful. Where is the transmission? Where is the evidence of transmission? There is no all the call details disproved. Then, my lords, the expression physical manifestation seems to be the phraseology used in the article.
As the judgment says, it doesn't say it has to be physical
Sorry, my lord.
transmission of thought.
Physical, that's what it says, my lord. The evidence.
Transmission of
Yes.
sharing the unlawful.
Before that, my lord. Before that, physical manifestation is also there, my lord. It is, however, essential that the offense requires some physical manifestation. Of agreement. Physical manifestation. Then, my lord, expression physical seems to be the phraseology used in the article referred to so and so. However, the said act shall not be the overt act, which is a different concept. As rightly said by the learned singer, the phrase refers to manifestation of the agreement, such as by way of meetings and communication. There has to be something, my lord. Then, my lord, I don't want to, this is, my lord, very illustrative. But 97, if your lordship sees between placetum E and F, the circumstances so prove.
It says overt act is not required.
Yes, no, but kindly see further. The circumstances so proved must form a chain of events. That is para 97, placetum E and F. The circumstances so proved must form a chain of events from which the only irresistible conclusion that the guilt of accused can be safely drawn and no other hypothesis against the guilt is possible. That's the standard, my lord. And then 90, Mela, I'm not going to labor again and again, but just, Mela, lordships may not read it. A few bits here and a few bits there, on which the prosecution relies, cannot be adequate for connection. So this is a few bits here and few bits there case, Mela. Para 99, the present case of the prosecution, if I can put it, my lord, in the words of the Supreme Court, is a few bits here and a few bits there. And there ends the prosecution story to convict. And my lords, this is on the conspiracy. Though what happens, my lord, in a conspiracy when the co-conspirator is acquitted? That, my lord, is 2013 7 SCC page 45, page 480, relevant portion at page 489.
You are saying that once they have been acquitted,
Yes, my lord.
chain is broken.
Correct.
So you can't do few bits here, few bits there.
To connect me again.
You can't do cherry picking.
Correct, my lord.
So now chain is broken.
Correct.
Once this is broken, you are treated as broken.
Correct. That's all, my lord. I just give the paragraph number. Paragraph, my lord, you can make a note. In this serial number 30, my lord, it is paragraph
You
number.
can't create a metaphoric link.
Correct, I bowed on my board.
It has to be physical link.
Yes, my lord. There has to be somebody. If I have to conspire, I alone can't conspire with myself. There has to be a co-conspirator.
And the transmission of thoughts cannot be spiritual.
Yes, my lord.
It has to be physical. That's
Correct, my lord. For the entire, whatever little I have learned of spiritual life, my lord, Guru transmits, my lord, his thoughts spiritually. That's the whole purpose of our Hindu, my lords, a Guru-Shishya relationship. My lords, you are aware, Dakshinamurti never spoke. It was only a spiritual transmission. But, my lords, when we are talking about IPC, there has to be a physical manifestation of that. Now, my lords, anyway, my lords, kindly see
If
just...
prosecution adopts that, then they'll say case is true. Guru has used his spiritual power.
Yes, my lord, that seems to be their case.
Communicate.
Correct, my lord. That seems to be their case.
And that is
Yes, ma'am.
not overt,
All right.
it's a covert act.
Correct, my lord. That seems to be their case, but it can't, my lord, stand in a court of law. Now, my lords, kindly turn to paragraph, page 489. I just...
Giving it back now, what is this?
No, the last point on this. That the co-conspirators are... I'll just... para 29 may be flagged, my lord. That's all.
29 of it. Read what is.
We will be failing in our duty if we do not note another submission of the learned counsel for the appellant. It is urged by him that A2 stood on the same footing as the appellant. The High Court should have acquitted him. Then, my lords, it is also canvassed by him that A2 has been acquitted of the charge of criminal conspiracy. Therefore, the appellant deserves to be acquitted. The High Court has taken note of the fact that A2 was not identified. Now, then, my lord, the court says, as far as conspiracy is concerned, under 120B, we are inclined to think that the High Court erred. Sorry. Yes, madam. In not recording any order of acquittal under one, as no other accused had been found guilty, the conviction under 120B cannot be sustained when the other accused person have been acquitted. That, my lord, is an old judgment, relies upon which we just gave. They rely upon, my lord, the judgment of Fakhruddin. My lord, where, my lord, the first point, paragraph 5 of that, the second compilation, my lord. Where I read that. Yes. Lords, one.
Saying that 120B essential ingredient is
Yes, my lord.
communication,
Correct, my lord.
meeting of mind
Yes, my lord.
through a chain,
Yes.
because conspiracy means number of people involved.
Yes, my lord.
Through a chain, if the chain is broken,
Yes.
then the charge goes.
And the second point is, if
Chain
the
is broken, therefore that reflects there is no meeting of mind.
and the second sequitur to this is, if the others co-conspirator allegedly have been acquitted, then, my lords, this person can't be roped in for one time.
It's break.
Correct.
Acquittal means break.
Correct, my lord. Correct.
If
Now, my
they
lords.
don't acquitted, you won't be arguing this.
Yes, my lord. My lords, there are two other judgments just to finish the latest. These are, I've cited old judgments. I want to cite the latest one on this, my lord. Of Justice Gawai, and I'll end with this. Just give that.
Hello.
Page 126.
Then
My lords, this is, my lord, Justice Reddy and Rishikesh Roy, paragraph 12 at page 128. It is fairly well settled to prove charge of conspiracy within the ambit of 120B. It is necessary to establish there was agreement between the parties for doing an unlawful act. At the same time, it is difficult to prove established direct evidence, but at the same time, in the absence of any evidence to show meeting of minds between the conspirators for the intended object of committing illegal, it's not safe to hold a person guilty for the offense, a few bits here, a few bits there, on which the prosecution of crime of criminal conspiracy, beyond the alleged so and so. So the same thing, not few bits here as Navjot Sandhu said, my lord. And the last judgment on this, my lord, is Justice Gawai, which is, my lord, the next judgment starts at page 131 and relevant, my lord, at page 138. My lord, principle, para 27 and 28. Principal ingredient of the offense of under section 1 is an agreement. Such an agreement must be proved to direct 27 and 28, my lord. Page 138, my lord. Sorry. The court has to necessarily ascertain whether there was an agreement. In decision of Sugatan, this court noted that an agreement forms the core of offense of criminal. Then not these bits and pieces, my lords, jurisprudence is put in, cannot be held adequate. The most important ingredient for the offense, now the italicized the last, my lord, placitum H, for the offense of conspiracy, some kind of physical manifestation is required. Express agreement need not be proved. Evidence of transmission of thought, sharing the unlawful act is not sufficient. Well, that is on 120B. And when we are on this compilation, my lord, the lordships have seen initially in May 2013, 3 people, students who are alleged to be there, they are not examined. Then Bhavya not examined. Then, my lords, the Sims are in the name of somebody else. Those persons are not examined. Why? And what is the effect of that? I just want to, my lord, if your lordships just see. Huh? If your lordships sees, my lord, the judgment of Gaurav Maini, which is 2024, starts at page, my lords, 343. Lord, Justice Mehta's erudite opinion, my lord, on how, my lord, the court should have appreciated. Please have a look at, my lord's paragraph 49. Page 362. When Bhavya says, my lord, that she was there, she's being coerced, she writes letters, etc., what should the court have done? Can it just be ignored, as the trial court has done here? That is page 362. A conjoint reading of section 311 and section 165 of the Evidence Act makes it clear the trial court is under an obligation not to act as a mere spectator and should proactively participate in trial proceedings so as to ensure that neither any extraneous material is permitted to be brought on record nor any relevant fact is left out. But I dare say, my lord, in this case, there can't be two opinions that Bhavya was a relevant fact. After, my lords, she could have been summoned and then her evidence could have been disregarded. But not summoning, my lord, is, according to me, fatal. It is due. 3 students also. Yes, yes. It is the duty of the trial court to ensure that all such evidence, which is essential for just decision of the case, is brought on record. May 2000, those 3 students, these, my lord, whose names are there, those Sims, Manju, etc., have you given it to Shilpi? Yes. Then similarly, my lords, para 51. We are fully satisfied the trial court failed to perform its lawful obligation under 311, read with 165, as the most vital witness whose deposition was imperative at arriving at the truth of the matter was not produced by the prosecution, and the trial court took no steps whatsoever to summon him. Then, my lords, the principles which ultimately the court culls out, 364, my lord. I said adverse inference has to be drawn. I said that I'll show the judgment. This is the line in the judgment, paragraph 53.7. The prosecution failed to examine the most relevant witness, Shamlar Girl, which compels the court to draw an adverse inference against the prosecution. Now, my lords, we come to what has happened on the 14th. Lordships have seen, my lord, the weight required for the purpose of proving conspiracy. And till now, my lords, there is no conspiracy, according to us. Your lordships kept on asking me, my lord, rightly so, what must have been the motive? Why are they trying to frame you? That I will come to, my lord, on 3-7, but I just want to indicate broadly, my lord. There was a professor So I'll show that and make that good by material, but today may not be required. But I just want to indicate, since the question had fallen from the court, I just want to give it a 2-minute answer. There was one, was a teacher, my lord, the school where this girl was studying. He was sacked in about April 2013. After the sacking, my lord, prosecutrix to her mother, but I'm not trying to shame here anybody, my lord, but since I am being put in a corner, I have to say all this. It's very uncomfortable for me. It's one thing to, my lord, wanting to clear your name, but I am not the one who wants to besmirch anybody. But since, my lord, I have to do this unpleasant task, your lordship will kindly pardon me. This person, this prosecutrix mother, my lord, has a phone. Has a phone, my lord. That number and all are well, my lord, documented, etc. When the prosecutrix is on vacation, and in the year 2013, there are 445 messages to this person. Nothing turns on it at first blush. She can have, my lord, conversation with a retired professor, no doubt. No problem. All, my lords, in that time frame when she's at home. Then, my lords, comes the fatal night of 15th for me. They say it's fatal night for them, but it's fatal night for me because my entire career has been finished. On the fatal night of 15th, incident happens between 10 and 11. And then the messaging starts with Pankaj Dubey after the alleged incident. Now, my lords, was it not the duty of the prosecution to bring those material on record? Because that would show what the prosecutrix was thinking just after the alleged incident. According to us, the incident didn't happen. Was she told at 11:30, 12 o'clock, frame him? And why this assumes importance is that, my lord, the prosecution does not file the call details despite an order of this honorable court of Justice Sandeep Mehta, which said, don't filter the call records. Please present all the call records between the prosecutrix family, whoever, my lord, that phone was, and the accused. And as we'll come to, my lords, the investigation, I will show selective, my lord, phone calls. The call records have been summoned only of the accused. Why? Because this was the, according to me, my lord, if your lordships were to ask me, my lords, human beings, ocular evidence, people may lie, may not, but not circumstances. If immediately after the incident, alleged incident, according to me, incident didn't happen. She never went to the kutia. But at 11 o'clock, 12 o'clock, goes up to till 12:05, early morning, late midnight, somebody is messaging using the mother's number and certain messages are sent. Is it not relevant? What were the messages? According to us, yes, my lord, the messages are it shows the call details. What happened, my lord? This person got arrested in another case. Because, my lord, the allegation, the Dubey, allegation against him was that, my lord, he was planting some skeletons in A1's ashram in Kashmir. He was arrested there. And the police recovered his phone. And in that recovered phone, my lord, these messages are there on the date of the incident to this girl. I don't want to say anything more. No, on the date of the incident. On the night, just after the alleged incident, according to us, the incident didn't happen. I just asked myself, my lord, So anyway, let's leave. But I'll show that. I'll show that. That's on the CDR. But I'll feel that because that was a. Yes, it is part of that. That is on the 15th. I'll come to it when on the 15th. But since your lordship asked me that question, I was duty bound to answer. Now let's come to my lords the 14th story. Justice Mehta's judgment, my lord. We'll give it at the appropriate. I'll just read it. I just read it, my lord. Yes. However, it is made clear that if the prosecution desires to file the call details in addition to the certificate of nodal officer, entire call details of the relevant without any filtering shall be produced on the call. Anyway, my lords, now my lords, as far as motive is concerned from the defense side, I don't have to prove motive beyond reasonable doubt. I am only saying that whether the evidence as presented by the prosecution can be credible or there is some other angle to this. That's all I have to show. I just have to create that doubt. That's all. But the trial court seems to suggest I have to prove the motive. That's against all canons of criminal to foist the burden on me. But anyway, my lord, I'll come to that. But please have a look at, my lord, how I want to start this. Now, my lord, still May 2014, I have shown, my lord, there can't be any conspiracy. Faced with this, how does the prosecution pin the conspiracy on me? Trial court says when they met in a public gathering on 14th evening, a lot of people were sitting. And in that setting, my lord, A1 looked at this person, prosecutrix, and say, "Oh, you are the Bhutwali lady." And what is indicating that you knew who she was. That's the case which has been set up. If your lordships were to carefully see the statements, it is clear, my lord, that father told in the satsang that my child has a problem. Problem was explained. And on being explained, the girl stood up. And when the girl stood up, A1 said, "Oh, you are the girl." How can that be the evidence of conspiracy? I won't straight away come to the statement now. What they did. Record page 46. Now, my lord, on the 14th incident, because after they went inside the gate and all that, not gate was opened by Shiva, which is formed to be false in the evening. Which that is, let's see the first one of the handwritten complaint. कुछ देर बाद उन्होंने पूछा, तुम कहाँ से आए हो? मैंने बताया कि मैं गुरुकुल से पढ़ती हूँ. तो उन्होंने कहा वो मेरे भूतकाल कंप्लेंट. एनजीओ रिपोर्ट. मणई में 14 की रात बापूजी ने प्रवचन के दौरान स्वयं को उसके माता पिता से मुलाकात की. 164. फिर उन्होंने मुझसे पूछा कहाँ से आए तो मैंने बताया कि छिंदवाड़ा से। तो उन्होंने कहा कि आ जाओ, कुछ निकालते हैं इस्तेमाल। फिर बापू ने 161 बापू ने पापा से पूछा कि कहाँ से आए हो। तो पापा ने अपने और मेरे बारे में, काइंडली नोट दिस मिनट, दिस इज अ कंप्लीट इंप्रूवमेंट बट 161। फिर बापू ने पापा से पूछा कि कहाँ से आए हो। तो पापा ने अपने और मेरे बारे में बताया, पर ऑन स्टेट। तो बापू ने कहा कि अच्छा तुम भूत वाली लड़की हो, आओ तुम्हारा भूत उतार। So my lord, whether the complaint version is true or 161 is true, it's credible. On this, can you pin me down? Then my lords, kindly see PW5 evidence. बापू ने हमसे पूछा कहाँ से आए हो। तो मैंने कहा कि छिंदवाड़ा गुरुकुल से आया भाई हूँ। तो बापू ने कहा कि छिंदवाड़ा गुरुकुल ओ छिंदवाड़ा गुरुकुल आपके मध्य परीक्षा का हाल। तो मैंने कहा कि छिंदवाड़ा गुरुकुल से आई है। तो बापू ने कहा कि अच्छा छिंदवाड़ा गुरुकुल की भूत वाली लड़की है, आओ तुम्हारा भूत निकालते हैं। इसमें बापू द्वारा आपको पूछना और आपके द्वारा बापू को बताना 161 के बयानों में कॉन्ट्रडिक्ट कर दी। यह सही है कि प्रदर्श पुलिस बयान है। बापू द्वारा पापा से पूछना और पापा द्वारा अपने और मेरे बारे में बताना लिखा है। बापू द्वारा मेरे से पूछना और मैंने द्वारा बताना अंकित नहीं है। आज कुछ कहा कि लिखा है। बापू ने कहा कि वो अच्छा तुम भूत वाली लड़की हो। अगेन मतलब क्लियर ये। नाउ my lords kindly see father. This my lord really goes. फिर हमसे बातचीत की। सत्संग में बैठे लोगों से मेरी गुरु भक्ति और श्रद्धा की तारीफ की। जब हमने हमारी बेटी की समस्या बताई, वो इम्पोर्टेंट है, जब हमने हमारी बेटी की समस्या बताई तो उन्होंने कहा कि हम अभी भूत उतारते हैं। Then my lords, चीफ आशाराम ने मेरी बेटी से पूछा कहाँ से आए हो। उस समय मैं भी खड़ा हो गया। पहले मेरी बेटी खड़ी हुई। मैंने खड़े होकर मेरे बेटी की प्रॉब्लम बताई तो मेरे बेटी ने बताया कि छिंदवाड़ा गुरुकुल से आई हूँ। वहां पर बापू ने कहा कि अच्छा भूत वाली लड़की हो, आओ अभी भूत निकालते हैं, भूत उतारता है। फ्रॉड मेरे मुख्य परीक्षा के पेज नंबर 3 पर लिखा है कि बात वहां पर बापू ने कहा था अच्छा भूत वाली लड़की। यह भूत बात मैंने पुलिस वालों को बता दी, लेकिन उसके बाद मेरी पुलिस बयान में क्यों नहीं लिखी मैं नहीं बता सकता। मेरे मुख्य परीक्षा के पेज नंबर 3 पर लिखी यह बात आसाराम ने मेरी बेटी से पूछा कि कहाँ से आए हो। उस समय मैं भी खड़ा हुआ हो गया। पहले मेरी बेटी खड़ी हुई। यह बात मैंने पुलिस वाले बयान में बता दी थी। पुलिस वाले ने प्रदर्शन TV2 में बयान क्यों नहीं लिखा। As we go forward, I will show, my lord, the very, apart from the fact that Bhoot wali ladki is completely demolished by the prosecution's own witness. You see this, he says, come, I will exorcise your ghosts now. And he tells them an upay. He says, aap Ahmedabad jao. And maybe tomorrow, whenever you want to. That will take some time. No? He says, you go to Ahmedabad and do Anushthan there. That's on the 14th. But what happens, my lord, they stay back on the 15th against his advice. Why? We don't know. So therefore, my lord, till now, my lord, in my respectful submission, the entire case of the prosecution seems to be some giant, my lord, plan to frame me.
मार्च में
After
26 में इसलिए नहीं दिखा। अच्छा ये कोई लोकल हॉलीडे है? लोकल है? लोकल हॉलीडे लगा।
18-19 पर
हाँ लोकल हॉलीडे है।
not with your lordship kind permission, Lord, can it be on the 18th and 19th? Sir? Well, I have some difference. Yes, sir. But that week we would court, Supreme Court is just opening, sir. 18, if it's possible, Lord, 18, 19. 12, 13th. Monday, Friday, a little bit difficult. Nowadays in Supreme Court, they are having miscellaneous for the 70th also. The 18th night, subject to your lordship's pleasure. Otherwise, my lord, on the 12th, my lord, 12th. 12th one day I'll do, my lord, then maybe. 13th. I'll do full day on the 12th. 18, 19. Well, I'll leave it to, I don't want to push beyond the point, my lord, either. 12. I'll make a request on the 12th.
Password only.
I am requesting for permission for one matter, my lord, of the single bench of lordship, my lord, for extension of bail ban. वो कल परमिशन ली थी my lord, वो कल के लिए अगर रिक्वेस्ट की मैं
अभी लगवा दो, यदि कल नहीं रहती दीदी
कल के अब रिक्वेस्ट
Not
दिक्कत तो एक्सटेंशन का तो लग जाएगी, वैसे भी चैम्बर लग जाएगी, नहीं चैम्बर हो जाएगी।
Or the court master can just complete the record. This is 1 to 12 may not be earlier part. So that's close, may not.
Take it as a cue from me.
No, I just wanted to compare. Anyway, we wanted to give it. Just we wanted to give it anyway. So this is just the outline of the argument. That the lordship's notes are complete. I don't. Grateful.
सर एक एप्लीकेशन सर ये नंबर 10 में क्या हुआ ये नंबर 10 में क्या हुआ सिंगल बेंच के लिए मोगा साहब
एप्लीकेशन देने का कोर्ट, हाँ कोर्ट के लिए है सर। अब वापस नहीं कोर्ट के लिए कविंदर 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 पहले बीच बंद कर पूरा। हाँ ले जाओ बाद में।